There we go.
Yep, it's there. Afternoon, ladies and gentlemen. We'll go ahead and get started. My name is Rob Leverett. This is the Election Subcommittee. So if you are here for a different committee meeting, you may want to change planes at this point. I'd like to ask Chairman LaHood if he would just open us up with a word of prayer.
Let's pray. Thank you, Lord, for this day. Lord, we just pray that you give us wisdom today, give us clarity, help us to honor you in all we do and say. And in Jesus' name, amen.
Thank you, Chairman LaHood. Appreciate that. We've got two bills on the agenda today. So we'll go ahead and call House Bill 426. Chairman Blackman, I believe that's yours. If you want to come up here or come to the podium, or if you want to just take a seat up here. I have no preference. It's your preference.
Will you ask him to read his LC number?
Oh, yeah. That's fine. And just to confirm, we have a substitute, do we not? Is it? Can you read that substitute number for us?
Yes, sir.
Oh, sorry. There we go.
It's LC 472268S.
All right. Thank you. Does everybody have that substitute in front of them up here? I think we do. All right. Mr. Chairman, if you want to go ahead and just tell us about your bill.
Well, thank you, Mr. Chairman, members of the committee. Bring before you a substitute here to House Bill 426. And I think this has been a conversation in process for a couple of years now. Just to give a little bit of history, we initially created a paper backup in House Bill 316 and then ultimately allowed ballot images to be subject to open records. And to further add to the accountability and transparency and verification process, this would allow ballot inspection of these paper ballots. I certainly have taken a lot of concerns from folks, and we've incorporated various language, and it's kind of evolved to some degree. There are other states that do this. Just kind of to talk a little bit about why I think, we're expected to be able to vote in secret, but not necessarily count those votes in secret, right? I think the citizen-run elections process is kind of an essential part of self-governance. So this would remove the court seal. It does not remove a physical seal, but it would remove the court seal. And I think to answer some of the other questions, it really does not speak to pre-certification, although I recognize some concerns to make sure that that's clear. This process goes on afterwards. But just to run through the bill, it's relatively simple in the verbiage on page 2, line 23. It strikes sealed, and again, that is the court seal. Same on page 3, line 49, sealed and. Moving on to page 5, the language versus hold, it's retain and preserve. and in a manner so as to prevent such ballots or other documents from being altered, amended, damaged, modified, or mutilated, including during any public inspection of such ballots. Once again, retained and preserved. And then if you jump down to line 123, it talks about the state election board promulgating rules and regs in order to enforce this language. Be happy to try to answer any questions if I can. I know there have been a number of suggestions, and they are welcome, and I submit to the wisdom of the committee on any other things that it may need to be considered along those lines.
Thank you, Mr. Chairman. I'm going to use my prerogative as chairman to ask one or two quick questions if I could. What exactly is the distinction between the court seal and the physical seal? So in other words, we're not removing a physical seal, but just the sort of the general court order that prohibits any further inspection would be?
Yes, sir. It would subject these to an open records request versus an actual suit in a court of law.
Okay. All right, thank you.
Not being a lawyer, that's my best understanding of it.
That was as good as any lawyer. You ought to play one on TV. That was great. And I think who we have.
And I can give you maybe a run-of-the-mill, I can give you a little run-of-the-mill, like maybe case, if it comes up as to where, this may be of some use, but I know there are other questions and things, so I can wait until that comes up.
All right, why don't we, I've got some questions, so why don't we go ahead and hit those. I have Representative Olalaye at the end there.
Thank you, Chairman. I just had a question regarding the court seal and its current purpose. If you could speak to the current purpose or function that the court seal plays in this process.
I think that is, if you are to have access, I think it's just what I just said, but I may not be answering your question. If you'd have access to these documents, you would actually have to be able to file suit and go through Superior Court. And if it was, say, essentially a statewide race, you'd go county by county and have to access multiple courts of jurisdiction. And this would just change that to more of an open record process, and leave the guardrails essentially up to the state election board.
And so if I could ask a follow-up question. Sure. So currently, residents have access to electronic ballot images. I know you mentioned that ballot images are currently subject to electronic review. This would allow residents to bypass superior courts and access through open records requests physical ballots.
I think it would just add to that open request availability the actual paper ballot in addition to the ballot images.
And what would be the need of a paper ballot versus the existing access that they have to electronic records?
Well, once again, I think the concept of, a citizen-run elections is kind of the cornerstone, and the transparency and accountability that's been built into the system. So, you would think maybe a case in point or your run-of-the-mill situation would be as if somebody were to get those ballot images and they found a set of which they felt like were perhaps did not measure up to specific standards as they saw it, then I think they could go in and try to track down the physical ballot and make sure that they align.
Yeah. And I appreciate the spirit of that intent. I think the reality and how I imagine it playing out is if this were to pass, you would have potentially a never-ending, unlimited stream of requests coming in from residents, correct? Would that allow that?
I don't know of that happening in the other states in which this is available to the citizens. I understand that concern, and I wouldn't want it to be weaponized for such, no.
And the reason why I mentioned that, Rep, is just the times we currently live in and how partisan things are. And that court seal provides a check against partisanship, and I would not want us to lower that barrier, potentially inundate inundating our local officials and staff with an endless stream of requests coming from folks who are upset at the politics of the day. But I appreciate you.
Thank you.
Thank you, Chair.
Thank you, Representative. Let's see, I think I got you off right. Who's next? Representative Bazemore.
Thank you, Mr. Chair. And my colleague hit on one of my questions also, overburdening the county staff with the requests, because I know in my district, I got from my officials, and they said they were getting requests just recently when we had the elections, and it was burdensome to them. It was overwhelming. And because SB 202, like I said the last time, restricts from other outside agencies giving money and donating money to help with elections, I see this as an additional problem for our county officials.
Did
So-
you want me to speak to that? Or?
Yes, please.
Well, I'm sympathetic to any additional burden. Our elections officials at the county level do an amazing job, and I support their efforts wholeheartedly, and have listened and changed some language in the bill based on their input. So I understand that. I think it's weighing whether or not the additional transparency and accountability is worth what may be considered a burden, but I think at the same time, is there a way to do that in a way that does not necessarily overburden per se, but creates that transparency and gives the citizens the oversight into elections. I don't think that we're intended for government to say, here's the results, we're going to put them under lock and key, and you don't have access to them unless you can afford to file a lawsuit and go through a judge. And that's, kind of the impetus behind the legislation.
Thank you.
Sorry. Thank you, Representative Bazemore. Let's see if I can. All right, Representative Maynor? Nope. Yeah, Maynor. Okay, there we go.
Thank you. I actually have a real life example to give. In my district, there was a special election for city council, and it was a 2-vote difference. And so that 2-vote difference ended up going to court. They had to go to court because people that wanted to see the ballots, they could not. And so they had the burden of hiring attorneys. They had the burden of doing a lot of extra things to go and see what were the actual ballots. So it's, there are always different outlooks on these bills. And so it sounds like the question we have is, what is the greater good? A citizen having a monetary burden, or the government having a workforce burden? We really need to be kind of making that decision, but I think that we should be looking at this from a citizen point of view, because in that special election, that was thousands of dollars that people had to spend in order to look at the ballots in front of a judge. That's my comment.
Thank you, Representative. Did you care to comment on that, Mr. Chairman?
No, I think that's true. It's about the voter.
Thank you. Any other questions of the sponsor? All right. We'll go on and try to move through some of our witnesses here. We've got quite a few. I think I have 10 people here. And so I think we probably, I need to allow Chairman Anderson the room at 2 o'clock. He very jealously guards his start time. So if y'all, I'm gonna have to limit you to about 2 minutes, which is not a lot of time, I know, but we just have a lot of people. I want to hear from all of you. So I'm just gonna go through the list in the order in which folks signed up. First, Cindy Battles with the People's Agenda. Is this the one right there?
Good Afternoon. Sorry, I need to check the time. I realize it's Tuesday. So first of all, I want to say thank you, Representative Blackman. You and I have been talking about this bill since last session, and I appreciate the multiple conversations and, honestly, some of the improvements. I still would very much like to see something. I know that you're saying on line 15 that none of this would happen before certification. I'd like to see language that makes sure that none of this happens before certification, because I think that it could be used to delay certification. I'd also like to see other documents defined, like what exactly are they going to be allowed to look for, because I don't want an election worker to accidentally throw away a piece of paper that had like a phone message on it and someone swear up and down that they have thrown away something that's imperative to the election. So if we had some sort of and then again,
If I could interrupt you.
Yeah,
You mean
absolutely.
other documents on line 94?
yeah, it actually appears on line 94, and hold on, it happens a couple of times in the bill.
Well, we can find.
I'm
them.
sorry, I should have like marked it but if we could like define what other documents are, and Chairman LaHood and I had this conversation today. I appreciate some things here about the state election board, because they are the ones who are supposed to be making these rules, and y'all are going to hear this a lot from me this session. One of the things that we're doing is we continue relitigating the 2020 election, and the Georgia Assembly is making legislation to try and appease some conspiracy theories. But I do appreciate the fact that we're giving the state election board the opportunity to make the rules that they're supposed to be making. I also agree with the points that have been made, because this is going to be another unfunded mandate. We are going to be asking election workers to do things, and you have Jones County. Y'all, my family's from Gray. I was just there yesterday. They have one full-time employee and one part-time employee, and they're going to be making these copies, and how much is it going to cost them? Like, I'm going to make the plug again. Please consider having a study committee, a joint study committee, where y'all are looking at the cost of this legislation for counties. Because, and I've said this to you, I know you love this analogy, y'all are asking for a Broadway production on a community theater budget. So if this passes, or if it doesn't, we need to look at what we're doing to counties and how we're resourcing them to make sure they can do their jobs and run their elections. Thank you.
Thank you. And I would say, Ms. Battles, having done some community theater, it's not as good as Broadway, but it can still be good.
As someone who has been nominated for an award for her community theater direction next to Martin, absolutely.
I thought you might want to get that plug in, so I tried to give you that opportunity. Yes, ma'am. All right, thank you. Is it Stephanie Ali?
You said it right too.
How about that? I occasionally do something right. Please
Just like the boxer, we're related somehow.
be sure to tell my wife.
I was worried when you started talking in community theater with Cindy, we were just going to go straight through my time. So I'm glad we got
No, we'll try to stay on schedule.
I'm glad we got it. So thank you, sir, for allowing us time. And I won't take too much of yours. I think members of the committee have brought forward some of the concerns that we have. I'm Stephanie Ali. I'm the policy director with New Georgia Project and the New Georgia Project Action Fund. And so I want to point out that many times as elections get closer, the counties that we work with through New Georgia Project, our sister organization, reach out to us about being understaffed, that especially in the past two cycles, in 21 and 22, that they have trouble finding people to work their elections. Not only because the pay is difficult to come by, especially in our small and rural counties, but because during the 2020 cycle, our wonderful people who sign up to do these roles, these citizen-run elections, as we were pointing out, faced threats, like real, credible threats of violence from conspiracy theorists, from passionate folks in the community who were over concerned about potential mistakes being made in those elections. It is our great concern that opening up ballots while the process is still going forward and making part-time or temporary staff be the person to answer those requests, process those requests in a time manner that has still not been kind of delineated, opens them up to more danger, more violence, more threats. I mean, it's not without knowing that just 2 people in Fulton County literally had to go into hiding for their lives because of this. We don't want to see any more of that, just like I'm sure no one else does. Many of the colleagues on the committee mentioned that this would be an overburden for counties to work for these requests while they are also in the process of going through an election, especially if this were one that had a runoff come right after it. We are on a shortened runoff session, and I know from having worked on doing voter education this past November-December cycle that is an insanely fast runaround for our folks who are doing amazing work to process ballots from November, turn them right back around for December to have the right folks on the ballot, and to put forward days of early voting, information for voters, make sure that everything is correct. So adding in any additional stoppage will make that more difficult. Yeah, those are our major concerns with this, and we just hope that we can find a way to open this up to those who are concerned about their elections while protecting the folks who are offering their service to our most important part of our work here in Georgia. Thank you.
Thank you very much. Let's see, is it Ann Gray Herring? You'll just come on up. We know who you are, but if you'll just say your name for our video viewing audience.
Of course. My name is Ann Gray Herring. I'm the policy analyst for Common Cause Georgia. Just have a couple specific things and to raise about this bill, and then a couple general concerns as well. Firstly, I will say that I just got the most recent version of this right before the meeting, but there's a section that's been added now to the end about the state election board promulgating rules and regulations, and just have some, general kind of confusion about what that is, because previously it was that removing the under seal provisions subjected these types of requests to normal open records request parameters. And this seems like the state elections board might create its own mechanism that's sort of separate and independent from the open records request. And just, would ask that we consider if that's really how we intend for this to operate. And if so, thinking through the details of what that would look like. For instance, it says that the state election boards will, dictate timeliness of responses. And that's something that a normal open records request doesn't have. And then, I want to echo some of the concerns about making sure this is only happening after certification, and just briefly point out that there's a counterpoint, or a companion kind of bill, I guess, or in the Senate side, SB 122, and lines 150 to 153 of that bill, has some language making it clear that it's upon certification of all matters on the ballot, and think, language like that could be helpful, as long as it also clarifies what documents it's referring to for the sake of inspection. And lastly, just generally, this body should consider the real risks of an unmanageable quantity of review requests, including those that are made in bad faith, and the limits of time and resources of county officials. Thank you.
Thank you. Let's see. Next witness is Paula. Is it Paula Reardon? Pamela. I'm sorry, Pamela. Excuse me.
So my name is Pamela Reardon. Thank you very much for this bill. I am a member of the Georgia Election Integrity Coalition. I live in Cobb County. I have spent, I wish I would have been tracking, but thousands and thousands and tens of thousands of hours since and including 2020 working, poll watching, and advocating for certain changes. I cannot understand why the previous speakers are so much against having election transparency. And election transparency would have really greatly helped in 2020. And I know it kind of like was new, got thrown on us, and a lot of stuff happened in COVID, et cetera, but I'm in favor of this bill. I wanted to point out that the added section is important, but also that I have like 5 pages here of these are the state election board duties. Okay, it's outlined in here, not in the bills. I'm sorry, this is separate. So there's a lot of duties that they have, a lot of importance. They do not have a budget. They have been working for the last 1.5 to 2 years with no budget. Apparently, Judge Duffy was appointed to the chair by Governor Kemp, but he wanted to ensure that he had a budget. There has been no budget so far. So if they are going to do these things, which they should be doing, there should be at least $2 million in their budget. And what the SOS has asked for, that's not enough. It's like a few $100,000s. Just wanted to make sure that people are aware of that. There are all these guidelines of what they're supposed to do. But should I say anything about the next bill or come up again?
Let's get you up again because your 2-minute limit is up.
Oh, okay.
I don't want to cut you off, but if you're going to move into the other bill, I think it's better to wait until we hear about that bill
all right.
first. But thank you very much. And Representative Maynard pointed out I've not been asking if anyone has any questions or wishes to make any comments, so I apologize for that. Does anyone?
She would like to make comments when they're done.
Okay, all right. If anyone on the committee does have any questions of these witnesses, if you'll signal up, we'll try to allow that. I'm just trying to stay on schedule here. Let's see. Is it Janelle? Is it Clodfelter?
Yes. Good afternoon, and I'm going to start my speed read.
Okay, thank you.
I support HB 426 as I believe it actually verifies the law. In September 2022, the CEO of Dominion testified to the State Election Board. He stated the following, and I quote, "The accuracy of the tabulator is the easiest thing in the world to double check. You pull out the paper ballots, the voter verified paper ballots, which is always the official part of the election. Those are the official results. Those are what can't be hacked. And you count them to verify the count of the tabulator." End quote. I agree with the Dominion CEO, with one exception, that it is the easiest thing in the world. We have been met with denial after denial, gavel of no standing for 2 years. Why would the powers that be deny trust in our elections by hiding the very thing that provides that trust? The official results that can't be hacked. The state of Georgia spent a boatload of money retiring machines that did not offer human-readable paper trail. The new machines were purchased, boatload of money again, would offer the ability to verify the accuracy of the tabulator. But every paper ballot ORR filed has been denied. Lawsuits dismissed. Federal law states retain and preserve. Georgia law states preserve. Neither say sealed. We preserve so that we can do as Dominion stated, hand count the paper ballots to verify the count on the tabulator. OCGA 501872 provides a list of documents that are not subject to open record. The word ballots is not on that list. HB 426, I am hoping, will magically convince the Secretary of State that counting of the voter-verified ballots is best practice in proving to Georgia that they can trust their elections. Most legislators from both sides of the aisle should be signing on to this bill. Legislators must understand that we will never trust an election that is unverifiable. Please vote yes to put this bill on the floor. And please also give the Secretary of State some money, and please give them a deadline to get the rules set up. Thank you.
Thank you very much. Did anyone have any comment or question? I do have that video if anybody wants it. Okay, thank you. Representative Manor?
Thank you, Chair. In the spirit of us passing legislation that kind of works with everyone, is there a way to, for the other documents, is it a way for us to define that a little better? The other thing I have a comment about is if we do this, what some of the speakers said, let's not do this process before certification. And if we did it after certification, and if it was found that there was going to be a change, what does that matter? Like, what happens? Nothing can happen after it's certified. So I don't really understand why after the certification part would matter, because once it's certified, to my understanding, it can't be changed. And then the other thing is, we talked about the runoffs and now it being a quicker turnaround. Everyone knows that government runs differently than private, or public runs differently than private. And so the quick turnaround will hopefully ultimately lead to better efficiency. The last comment I have is with the state election board, I did not know that they were volunteers and they had no budget. And so are we passing something for the state election board to do, and they have no budget to even do that? And then the last thing is the somewhere in here it mentions the timely response, and someone said that the Open Records Act does not mirror that, but I feel like the Georgia Open Records Act has like a 30-day window, and those are my 3-day window.
Yeah, it's a 3-day window to respond whether or not you'll produce the documents. You don't have to actually produce them in that time if it's not reasonable to assemble them and provide them. So there is you have to say what you're going to do within 3 days, and then there's no real deadline on when you do it. It's just reasonableness standard, I think. So at least that's my understanding as a guy who's done some local government law and had to respond to them before. So that's something I think we can probably get some verification on. But I don't know that I've got answers to all of your questions, but I think they are valid ones. The sponsor had to leave, but I think those are things we maybe should try to address with him and perhaps legislative counsel for the benefit of the committee, so we can, because I think some legitimate concerns have been raised. Did you have any further comment? No. Okay, all right. Representative Olalier.
Thank you, Chair. Just to respond to one of the items brought up by Representative Maynor, I believe that the concern around before versus after certification is when you remove the court seal in this environment that's highly, highly, highly partisan, this can be used, audits, nonstop potentially sham audits can be used to delay the certification process, which only further deepens distrust in the process. So I think that's the fear. There is access to ballots going through the normal court process. So to say that that access isn't available is false. There is access, but there's a step to prevent sham audits or an endless stream of audits overburdening staff on the local level, but also audit requests or open records requests that aren't in good faith. Thank you, Chair.
Thank you. Representative Maynor?
And thank you, Chair. Anyone on the committee can answer this question. So if the audit was done after certification and it was found that the audit flipped a vote, what happens?
Yeah, I don't think we know. Perhaps some of our witnesses can address that. Stewart, as legislative counsel.
So my question, Stuart, was if we did the audits after certification, so the certification wouldn't be delayed. If the audit was done after certification and it was found that the results were flipped, what then happens?
We'll probably have to go to court as a contested election at that point, probably, because it's already been certified.
All right, I think that's probably an issue we need to drill down on, but it sounds like it might require some sort of court action, or the local officials could recertify of their own accord if they chose to do so. But I think that's an answer we probably ought to look at as we consider the legislation. Representative Bazemore.
Thank you, Mr. Chair. And based on the conversation that has just taken place, maybe we should get some more answers before we move forward with this bill.
We haven't made that decision yet, but we will do so shortly.
Thank you, Mr. Chair.
Thank you. Still want to try to finish the testimony. Tamara Favorito, if you'll just go to the podium there and say your name and we'll hear from you.
Thank you. I'm Tamara Favorito, and I would like to thank Chairman Blackman for introducing this bill to unseal the ballots, which makes them public record. And I want to address your question as to pre-certification versus post-certification. The court order to seal the ballots only happens at the time of certification. So the ballots are already subject to open records requests prior to certification. So that's why this bill is addressing just after certification. I do speak today in support of the bill, and my mic is cutting in and out. I'll be loud. Unsealing the ballots is the most important action the legislature can take for fraud prevention, honest election results, transparency, and to restore trust of the people. And again, Representative Maynor, I really appreciate your comment about looking at it from the citizen's point of view. An open records request can be charged for to offset some of the cost. It has to be reasonable, of course. It also, unsealing the ballots also allows counterfeit ballots to be detected and electronic votes to be verified. And there should be no concern regarding the security of unsealed ballots due to the wording in lines 90 through 95 of the bill, which require the ballots to be retained in a manner that prevents them from being altered, amended, damaged, modified, or mutilated. Now, I do have a concern about the section starting in lines 123 to 130, where the state election board shall promulgate rules and regulations around making these ballots available. As has already been mentioned here today, the state election board has no budget, and they are very far behind in rules that they should have written in the last year or two. So my concern is what happens here if they don't come up with rules, and I don't know the answer to that. But election transparency really is a nonpartisan issue. We should all be able to agree that it's a good thing. There is no honest or rational argument to oppose unsealing the election of ballots. There's no voter identification information on these ballots that require it to remain a secret. So I really, once again, want to thank Chairman Blackman for trying to improve security of our elections. Thank you.
Thank you, Miss. And I usually say favorito, but it's favorito?
You know, we get both.
Okay. Well, I like to try to do that. With a name like Leverett, I get a lot of wrong pronunciation, so I'm sensitive to that. So, well, thank you very much. I don't see any comments or questions from the committee, so, Mr. Garland, if you want to go ahead.
Mr. Chairman, I've got a document to submit to the record.
That'll be fine.
Help answer some questions. Thank you, Mr. Chairman. Just wanted to reiterate a couple of quick points there. As Tamara mentioned, the court seal on these documents applies after certification, and the ballots are transferred to the clerk of the court. So this is not addressing pre-certification. Also, the open records request, you can be charged. The officials can charge for open records request, reasonable charge, so that's not an issue. And then the third thing is, Tamara said the state election board is years behind in making rules. Even they have some rules right now that violate federal and state law, which we're almost forcing to sue from. I would like to suggest to change line 123 where it says state election board shall, simply to change the word state election board can. And I think that would solve that problem. But what I really want to do for the remainder minute or so is to address Representative Olaleye. I cannot say this. Olaleye. Wow, that's a tongue twister. He made some very good questions, and I wanted to address those. I'm going to leave this document. But the question was, wouldn't ballot images suffice? And why do we need to have ballots as public record? Because we passed ballot images in Senate Bill 202. Well, what we found out when we actually analyzed the ballot images statewide, in particular in regards to Fulton County, the ballot images were electronically altered prior to certification. And I've already testified under oath this in court, in Fulton County Superior Court. We proved this a dozen different ways, and we gave every member of the legislature a copy of our documents last year. I'm going to leave another copy for the record. Right now, a ballot image is required to make a vote. But right now, in the Fulton County 2020 certified results, there are 17,324 votes for which there are no ballot images. So the only way you can resolve what actually happened in 2020 or 2022 or any other election in the future is by making ballots public record. So this is the single most important security thing and integrity thing you can do for elections. So I'm grateful for the chair hearing this bill. I'm grateful for Chairman Blackman for introducing it. And this bill almost got passed last year. It was down to Senate Bill 89 in the last minute of sine die. With the language was in there, but it didn't get out of the Senate. But I thank the House for passing that last year. And I'm happy to leave this with you. And Representative, I'll be glad to work with you on this so we can give you some more information. So thank you very much.
Thank you. Thank you, Mr. Favaretto. The next, I've got Todd Edwards and Joseph Kirk, also known as the dynamic duo of the Elections Committee witnesses.
Cool. Hey, y'all. My name is Joseph Kirk. I am the election supervisor from Bartow County. I appreciate you having me here today and hearing from me. Thank you to Chairman Blackman for his work on this bill. I worked with him last year on it, again this year. I appreciate everything he's done, the changes he's made. One small point to get us started. There's 3 sets of records after every election. Generally, the counties, the states, and the clerk of courts. The counties and the states are already subject to open records, and that's how I fulfill open records requests. The records we're talking about now do not exist until certification, when we have to transmit all these documents to the clerk of court, and all the code sections this talks about, it specifically comes into play at that time. No, they're not open records before that. We're still using them, we're still certifying them, and then we transfer them to the clerk of court's custody. And the idea, as I understand, to answer the question you asked earlier, is so there's a frozen moment in time. That if there's a question about the election, there's a question about my conduct, my staff, something that happened with a voter, I can't be accused of going back and changing that. So I don't have access to those anymore. So as you're talking about these open records requests, those will not be elections employees. They'll be, in most cases, clerk of court employees or county employees who are charged with open records as part of their daily jobs. But some offices do have that responsibility, so there's a little nuance there. And again, they're sealed for the protection of everybody involved. And in the event of a lawsuit, that's where the judge goes to get their stuff. Images are available through my records, not the original ballots, nor are the absentee ballot oath envelopes available in mine. Only place they exist is in the clerk of courts. Now, I don't think this is a good idea, but that's just me. And as I just said, that's at this point, it's really none of my business. And those records are not mine anymore. I give them to the clerk of court or to a record retention department, and they sign off on it. They're not in my custody. but we're losing a layer of protection we have for our election officials in doing this. But if this is the way y'all want to go, like I said, it's not my call, it's not my business, but I love the SCB rules and the addition of them, a little bit of direction that my predecessors went. I would say to require the rules be in place before this is used, maybe give them an end date to prioritize the creation of these rules so we're all on the same page for this, so that, for example, prepayment of personnel costs, prohibit the folks requesting dollars from handling the documents. These are the original ballots, one of the most important records of the election. And the more they're handled, the less trustworthy they might be. So some way of protection there so that y'all can see what you need to see, but the records are not suspect afterwards. As far as the seal goes, that judicial seal, it's more of an idea. The boxes I turn over do have a numbered seal on them. Not every box does. So if you want that to be sealed, you want a numbered seal on that, you need to specify that. It's not in the law right now. And then talking about this separate open records process that came up, it doesn't need to be separate. These are ballots. They're special. We need to treat them like they're special and make sure we're protecting them from any kind of tampering. I'm not saying necessarily don't release them, but be sure those protections are in place. I'm not against transparency in any way, shape, or form, just pro guardrail. And that's everything I've got for you if you have any questions. And I think Todd has something to say as well.
Thank you. Todd, if you have some comments you want to make.
Yeah, thank you, Mr. Chairman, members of the committee. I'm Todd Edwards with the Association County Commissioners of Georgia. Appreciate being with you today, and I'll try to keep it short and brief. ACCG has serious concerns with this legislation before you. I think, as Joseph, thank you. I got audience feedback back here. Peanut gallery, so to speak. So following the certification of elections, counties are required to keep one copy of the ballots sealed in case they are needed for audit or the courts. This legislation, as you know, will unseal them for members of the public to inspect them. Why are they sealed? It acts as a safety net, as Joseph said, for the elections workers, and no one can accuse them of being a citizen or tampering with those records. What are the realistic expectations should this legislation pass? Well, folks, in looking at these ballots, aren't going to be able to handle them. Why? Because the other side doesn't trust them to do so. They'd be accused of all sorts of malfeasance in the election process. So that leaves county staff having to handle them, perhaps feed them, show them to those at request. As asked earlier, there are no limit to the requests that can be had. Emergency filled of those, and believing right or wrongly that our elections are filled with fraud in the state of Georgia. They will be lining up to see these ballots. We're already flooded after each election. This last election in Georgia, our election superintendents, untold open records request, all 159 counties, all statewide, and we think that this will add to it. That was between the actual election and certification. There is discussion on making this applicable after the certification, but it will still be those same parties. It was earlier asked if audits pointed to a different answer than the actual election did. Which interest group are you going to trust that are out there inspecting these ballots? They represent both sides. They're very well funded. They'll be very involved. I would argue that is for the courts to resolve, not somebody going in there and inspecting with their own personal team what the ballots actually say. That's what courts are for, and that's why the ballots are sealed. As more and more of these bills will definitely impact the ability of Georgia counties and our election officials to administer elections. We see several more in the Senate right now. The long-term consequences is going to be harder for folks to fill these jobs. It's going to be more expensive for counties to process these requests, and it will impact our election administration. I had more, but in the interest of time, I'll stop there. Thank you, Mr. Chairman, members of the committee.
If I may add one last thing, just a suggested change. If you move forward, the bill currently specifies copies and rules about copies. I believe y'all are going to want scans as well, so you might want to include scans and the resolution of those scans in that language.
Okay, thank you. Thank y'all very much. That's the conclusion of our witnesses. I think we've had a pretty good discussion, but there's some issues that have been raised that I think we still need to get some answers on. I think what I'd like to do is just have this as a hearing only today, and let's see if we can't bring the bill back next week, try to get it hopefully out of committee, maybe do a little scrubbing on it. So, is that agreeable with everybody? All right, well, that concludes that particular item. We've got one other matter on the agenda today. That's House Resolution 110. I believe Representative Alexander had a unavoidable conflict, and I believe. Oh, there she is. See, if we take long enough, you can get here. Why don't you come forward and tell us about your bill? Well, I was looking at Representative Bazemore stepping into the breach for you.
I know. Thank you, Mr. Chairman. Thank you, committee members. My bill is very simple. This bill is proposing a study committee, a House study committee, to go back and review. We had 52 sections of Senate Bill 202. So we have yet to hear from some of the election superintendents and various people around the 159 counties whether or not we have issues. And we have heard from some, but what this bill will do is just allow us to go study election integrity, considering the fact that we have every year, we have so many bills that come up on elections. It would allow us to go back and study it and then bring forth a bill to correct all those issues. That's it, simple.
All right, thank you. And I believe the bill contemplates 7 members appointed by the Speaker. And so it would have a term, I suppose, of just one interim between the 2 sessions.
Yes.
Yeah, okay. Representative Maynor.
Thank you, Chair, and thank you, Representative Alexander. Who are some people that you are envisioning to provide testimony during the committee hearings?
Well, I hope we'd hear from some of the people in the 159 counties that have to deal with elections every election year. So I'm sure they would know if there are issues that have come out based on Senate Bill 202. So of course we want to hear from those people, or if there are anybody else that want to come forward and have anything to say about Senate Bill 202. But specifically from the people in the communities, the people that are at the election offices, those individuals will know what kind of issues they've already had.
Thank you. Representative Bazemore.
Thank you, Mr. Chair. Thank you, Representative Alexander, for bringing this bill forward. And I think it's imperative that we look at this, pass this, and conduct that study committee so that we will know what is needed going forward from those that are in charge of the elections. Thank you again.
Thank you, Representative. All right, any other questions for the sponsor? Anything that you wanted to add in closing,
No.
Representative?
Thank you guys for hearing me today. Appreciate
Absolutely. Appreciate you getting here.
it. Thank you.
And we do have some folks who had signed up to speak to the bill. Ms. Clodfelter, if she's still here.
Just as I love the last bill, I love this one as well. I think it will be marvelous to have people come and speak and let you know what's been going on. I would like for Ms. Alexander to possibly add poll workers into that mix, because I personally have witnessed more voters disenfranchised in a almost 100% Democrat precinct than I care to discuss. And I would like to tell you why that is the case. As well, I would like to talk to you about the burdens of the machinery and having to put them up within an hour and a half in the morning and have them ready to roll with the DOJ over your shoulder. I hope you get that bill passed.
Thank you. Thank you, ma'am. Any comments from any members of the committee or questions? All right, I believe, Mr. Kirk, you signed up for this one also? Yes. What was that?
I did too. I put it on the same line as the other one. Right below. Kind of under it. Sorry.
Oh, I see. Yes, ma'am. All right, so we'll get you up here in a second.
I will speak quickly then. I apologize. So one thing I didn't mention before, again, I'm Joseph Kirk from Bartow County. I'm here speaking for myself, not my county, not my association, anything like that. I think it's important to mention. I think election study committees are just a good idea. This is a very nuanced thing. It's a very simple idea, but the implementation is complicated. And we seem to be focused on a few issues and missing, in some cases, the forest for the trees. There's things like, runoffs we need to look at, increasing audits, our reconciliation practices, list maintenance, all these things that we're not talking about while we're focused on one or two things just in there with it. So no matter how it's formed, I think this is a good idea. I hope it moves forward. The idea of election integrity, it's not a destination, it's a journey we need to keep working towards. We'll never get there. We'll never get to a point we can just stop and step back and move forward the way we're doing things. We should always be looking at the next step, the next small change that moves to a big change that really increases transparency, increases public confidence, and increase that voter's experience. So I think this is a great opportunity, and I hope that you vote for it. Thank you.
Thank you. And also, I see Ms. Battles had signed up too. Sorry about that. So Ms. Reardon, if you want to come on up.
Thank you. So how do I explain it? I'm sort of in agreement with this resolution, but I can see that when the author spoke, she only spoke about mechanical issues, maybe running, the timing, the amount of time, that they can open up the ballots, the AB ballots, absentee ballots, and, count them and stuff like that. But like the gentleman just spoke about, there are bigger issues. There are bigger issues with respect to list maintenance, because the post office, I don't know, there's a recent article that they just don't even have the right addresses to a good many percentage of the people that they send the mail to. And it's a mess. People move. I'm in real estate. People move 10% every month. Maybe not so much recently, but list maintenance is a problem. I think we need to have closed primaries. That would help. And I think we need something on citizenship, and we need to protect vulnerable voters, because we had a situation in Polk County where we had like a 23-year-old that was running. He was a supervisor of the elections, and a lady came in from the senior citizens, that is the memory care, wanting to get applications for all the people in there. Now, I know people, I go there, I do the work in there, and memory care patients cannot vote. They don't know anything about what's going on. I'm just saying, this is the fact, that's why they're there. They should not be voting, and people should not be voting for them. There are many things like this that need to be looked at. So if this resolution is going to include things like that in people in the community, then I'm for it. If it's not, then I'm not for it. Just how it is.
Thank you. Representative Bazemore, do you have a comment?
Yes, thank you, Mr. Chair. Just to speak to what was said, I think in the bill it does address any discrepancies and concerns. So it says that, not just targeting it on a certain. Thank you.
Sorry, I'll be really, really quick. I know you didn't call me, but you had said I was next. So.
That's fine. That's saves time.
Trying to make your job life easier. Cindy Battles, People's Agenda again. I understand that Representative Alexander had to leave, but I would kind of speak to what Joseph Kirk said. If we could expand this to talk again. Sorry, I'm preaching again. To the cost and the resources that election supervisors and counties need to run the elections. I would love that, and y'all have to put up with me at every committee hearing, wherever it was in the state. So that's all I have to say about it.
Thank you, ma'am. Yeah, I was just looking, like most study committee resolutions, it doesn't specifically define the scope of what would be looked into, so that's something that could, I think, vary. Representative Maynard.
where the chair was that the last speaker?
I believe it was. We hit everybody at this point, I think, haven't we?
Okay. I was just going to say that I do think it's a great idea to look at election integrity, but also all of the other things that the last speakers just mentioned. And also, I'm just wondering, has the state election board, the Secretary of State, all of the different counties, have they ever come together and had their own conference and speak about what issues are?
Yeah, and I don't know an answer to that question either.
Okay.
I'm afraid I'm full of more questions myself today than answers. All right, so I think at this point, Chairman Anderson's going to come over here and rap on the back of my head if I don't turn the room over to him. I think we've raised some issues about this bill. It's certainly of interest, but Chairman Blackman thinks I'm singling him out. I think I'd like to just have this be a hearing only on this bill too, and let's look at it a little bit as well. Yes, sir.
Just very briefly, I appreciate that. I apologize. We had a GDOT board, second district election, and I had to step out. And I so
on top of each other. I understand.
Very much
completely.
apologize. Appreciate all the feedback, and look forward to trying our best to perfect, if possible, the language in the legislation. That is for everybody but Mr. Edwards over there. I'm just kidding.
All right, thank you, Mr. Chairman. All right, now, so we'll say this is hearing only for today, but we'll keep the conversation going. I need to turn the room over to Chairman Anderson, so I'll declare the meeting adjourned unless there's any, Mr. Chairman, I need to end. All right, thank you all very much for your attendance today.
We'll get started with the subcommittee meeting, and if I can have everybody's attention, we'll get started with the subcommittee meeting in just a few moments. In the meantime, there's a sign-up sheet on the table on this end of the room. If anybody wishes to speak, we will be hearing two bills today. I think House Bill 72 has been removed from the agenda, so we'll be hearing the other two bills. I don't have that paperwork right in front of me, but the other two bills will be on. 374. Yeah. Okay, we will now begin the subcommittee on state and local government for the Governmental Affairs Committee. Appreciate everybody coming in today. And the first bill we're going to discuss today will be House Bill 374 with Representative Thomas. Representative Thomas, we'll let you take it away.
Thank you, Mr. Chairman. House Bill 374 creates an alternative method to de-annexation. I actually carried this bill originally last session. It was HB 1439. It had a hearing. One of the major pieces of feedback I got was the original 1439 didn't carry the 60% method, so we added the 60% method back in. I think a couple things worth noting is it still allows for the standard methods of de-annexation, being through the city and through the General Assembly, with one small change. It does require the adoption of a resolution by the county. I think that, and that's specifically on lines 5051, page 3. And I think that has to do with service delivery. I think that's just a good thing in general. If someone's going to de-annex out of a city, they probably should make sure the county is okay with doing the service delivery. So, additionally, it requires payment for any bonded indebtedness that's created. So those people that live in that area, those parcels that are being de-annexed, they will have to pay taxes. It creates a special tax district. It does that in lines 96 through 108 on page 5. Additionally, as I said before, we added the 60% method in, so it still requires a resolution adoption by the county. That's on page lines 215, 216, page 10. And it does so because, again, we want to make sure that we're doing what we need to do for service delivery strategy and agreements. Additionally, it allows, the 60% method includes a arbitration panel that's identical as the annexation arbitration panel. So if a group of this, and this only applies to the 60% method, if say a large group, they want to de-annex through the 60% method, then they would go through, they would have a referendum. The referendum would get voted on. At that point, the cities would have an opportunity to go to the county, and they can actually fight that out in the standard way that they do it on the annexation 60% method. So it's really parity between the two, the annexation and de-annexation. They're really parity with the parity with the exception of the 100% method. So I'm going to bounce back to 100%. On 100% method, one of the specifics is I did try to allow for some opportunity to object to that process just in case. And those are really health, safety, and welfare of the residents and property owners of the area to be de-annexed. If there's an issue, then the city could, they could object under that reason. So I'll be more than happy to open up for any questions. That's the base run of it.
Okay, thank you, Representative Thomas. We do have a couple of questions. I think Representative Bernal.
Thank you, Mr. Chairman. I remember this bill from last year, and I remember that there was something on here about that if the residents, those that wanted to de-annex, would have to get their own attorney. Do you remember that discussion we had about them?
I've slept a couple times since then.
Well, it was something about that they would have to pay for their own attorneys to de-annex.
Well, I think that's probably appropriate. I mean, if someone wants to de-annex, they should cover their own legal fees. So, but I'm not familiar with the specifics of what it is that you're talking about.
Okay, I'm gonna go back and read it through very carefully, then I'll be able to ask you.
Yeah, we got time.
All right, thanks.
Representative Williams.
Thank you, Mr. Chairman. So I'm thinking about the Mableton situation, city of Mableton, where we have a fairly large number of people who want to de-annex. Is this a procedure that would be applicable for those folks?
I can't speak to the specifics of a situation I don't know. Here's what I could tell you: is one is what this bill does is it basically holds municipal governments accountable, and it does so by the way of, you know, I think the best way to say it is when you annex into a city, and you want to de-annex out of a city, you have to go to the same people you asked to get let in to get let out. That just seems wrong to me. What this does is it actually sets up an alternative option, and that you go to the county government. Now, I want everybody to remember the county, whoever that is, usually Board of Commissioners, these are elected officials by these people who I would believe is, you know, a neutral party that can listen to this and provide a fair and balanced opportunity for the case to be heard. Because it's really hard for somebody to say, well, now you're in, you're in. And I'd also like to mention the state government recognizes that de-annexation is something. It's not like, you know, the United States where we're indivisible. I mean, cities can annex and de-annex. So this is just an alternative method. It just adds one more way of doing it.
Okay, thank you.
Yeah.
Thank you, Representative. Any other questions or comments on the part of the committee? All right, seeing none. Thank you, Representative Thomas. We do have a few people signed up to speak to the bill. First, I'll call up Mr. Todd Edwards. If you'd like to just come to the podium, introduce yourself, and proceed.
Thank you, Mr. Chairman, members of the committee. Again, I'm Todd Edwards with the Association of County Commissioners. ACCG asks for your favorable support on House Bill 374. I think the author did a pretty good job explaining the outline of the bill. We've been interested in this legislation for some time. There's always, and has been traditionally, a lot of conversation at the General Assembly about city incorporations, annexation. I know last year was major legislation, and recently the annexation arbitration process. At the center of these debates is which form of or level of government best suits the citizens, which offers more efficient services, more favorable, denser zoning, land use, or greater self-determination. Much has also been heard about respecting individuals' private property rights. So in recent and past annexation discussions, we hear that citizens ask to be annexed. Cities don't go out shopping for them. We hear property owners have the right to petition a city for annexation without a county being able to block it. Annexations are the the natural way cities can accommodate landowners who want to be served by local government. And Georgia annexation law is based about individual choice. But once an individual is annexed, should those arguments still ring true, or should they be any different? Under current state law, you can ask a petition in a city to be annexed. You can be annexed without the county's permission or consent, but once you're in there, you cannot get out or de-annex without the city's consent. And that's what this legislation is all about. Now, you can, I guess, go through de-annexation through the local act. That trumps everything else, but an individual citizen cannot de-annex from an incorporated municipality without that city's consent. This bill tries to address it, as mentioned before, both through the 100% and the 60% methods, as we call them. I will get to a couple of questions that were asked on Mableton. Sure, if the city was established, they had their boundaries rather than having to go through a local act to de-annex any particular portions. I know it's a hot topic, but this would give citizens the ability to do so. But there are some safeguards in there, and I do want to talk about those. So, again, it makes pretty much similar the act of de-annexation and annexation across the board. De-annexations would not be automatic. As the author spoke, you would first need a county's permission to make sure that they could provide services prior to the de-annexation. The use of the same dispute resolution process is currently in place for counties who wish to object to an annexation. It prohibits unincorporated islands. So in Mableton, we'll say, for example, someone in the middle of the city could not just annex their property, and they would have to abut contiguity, same as under the current annexation process on the boundaries. Cities could continue to provide water and sewer service. In fact, they could charge 2 to 3 times as much now that they're in the unincorporated area, which is common practice for cities, at least twice as much, serving unincorporated areas with their water and sewer systems. They've got effective tax dates, that take into consideration schools with independent school systems, addresses bond indebtedness. It goes on with the protections. In the interest of y'all's time, I won't go any further, but I'll be happy to answer any questions. In short, we believe it just makes equitable the process of de-annexation similar, mirroring annexation law. We believe there are protections in place. There's a dispute resolution process. We would urge your favorable consideration, and again, I'm happier answering questions if y'all have any.
Thank you, sir. I do have one light flashing here. Representative Burnell.
Thank you, Mr. Chair. What reasons do they have to give for wanting to be de-annexed? Because I know with cities, we had one city that said they wanted a park. So what are some of the reasons they would have to give for de-annexing?
I don't know if the reasons are cited as must be given, but I can imagine what some of them may use. Perhaps they annexed into the city some years ago, were promised a certain amount of a higher level of services, so to speak. They weren't granted them. They might say, well, why pay these extra taxes, or it doesn't suit my individual, needs. Why can't I be able to de-annex without the city's permission? But I don't know that the city lists what conditions must be met, other than that the objections could be based, if it, from the city's part, if it negatively impacted the public health, safety, or welfare.
Thank you.
Okay, any other questions for the speaker? Seeing none, thank you, Mr. Edwards.
Thank you.
All right, and at this time, we'll invite Mr. Jim Thornton and Mr. Patel. Is he going to join you? Yes. Okay, thank you.
Thank you, Mr. Chairman, members of the committee. I'm Jim Thornton, the Director of Governmental Relations for the Georgia Municipal Association, and I'm joined by Rushi Patel, who is General Counsel for GMA. And we wanted to share the concerns that GMA and our member cities have with the legislation before you. I'm going to speak to a few broad concerns that we have with the legislation, and then I'm going to ask Rushi to drill down into some specific issues with the language of the bill. To start, I would just acknowledge that for many years, the bias of the General Assembly has been towards effective planning as it relates to local government. State policy has encouraged cooperation and negotiations between cities and counties. The result of that has been comprehensive planning requirements, periodic service delivery negotiations, and ongoing consultations between cities and counties. This is necessary because Georgia is a very complex state. We have 159 counties, we have 537 cities, all of which are members of GMA, and each individual context and situation is a little bit different. But the General Assembly has been very thoughtful in encouraging discussions, requiring annexations and de-annexations to be considered on an individual basis, and allowing all of the affected parties, the cities, the counties, the residents, the landowners, to be part of that conversation. What I think I would like to emphasize today is that de-annexation is very different from annexation. They are very different processes. This bill and the testimony you've heard attempts to portray annexations and de-annexations as comparable and to mirror the process. But that doesn't actually level the playing field, because there is a fundamental difference between when a city and a county engage in annexation or de-annexation. In both instances, the land always stays in the county. That never changes. The county retains taxing authority over the land, collects property taxes, often at the same millage rate from both city residents and unincorporated residents. And while counties typically provide all services to unincorporated residents, only some of those are provided to the incorporated residents. But the analysis is different for a city. In the case of an annexation, the city acquires a new role, and typically the reason for that role is to provide a higher level of service for the residents, but the residents don't leave the county. Cities normally accept many, if not of the service, most of the service delivery responsibilities. In a de-annexation, the property and the residents actually leave the city. The city loses the taxation and regulatory authority over those areas that are de-annexed, and they don't lose the service delivery responsibilities, particularly if the city has provided utility services or other services to that area where the service obligation is likely to remain. So in those instances where a resident or a property owner wants to de-annex, they are able to request that. The city has an opportunity to evaluate and engage in that discussion to see what issues it might cause. In fact, data that's been collected by DCA shows that over the past few years, dozens of de-annexations have been approved by cities. So this does happen. And as was mentioned earlier, there's always the possibility of relief through a local act if for some reason a landowner or resident is unhappy with the process. Over the years, the General Assembly has shown a policy preference towards contiguity, towards shapes that make sense of cities. The General Assembly has looked disfavored unincorporated islands, spoke annexations, other weird shapes on a map that might exist in a city. The legislature passed a specific law to create, to prohibit the creation of unincorporated islands. The reason for all of that policy preference has been service delivery, because it becomes very difficult for cities and counties to coordinate services when there are overlapping jurisdictions, when you're having to cross different areas to respond. That is why de-annexations have to be evaluated by both the city and the county when they are taking a look at this. Under the proposed legislation, this essentially gives the city a very limited role in objecting if there is a proposed de-annexation, and that could result in the impairment of the ability for that city to provide services to those residents most effectively. There are a few things, and as I mentioned, Rushi's going to go into some specific issues with the language of the bill, but I think there are a few things that should be pointed out the bill does not address, which we think are very critical to cities and counties for that matter. The legislation does not address issues related to lost distributions. Lost exists in, I think, 148 counties that collect a lost. It fails to take into account all of the factors that are resolved in those negotiations. The legislation does not provide a reimbursement to a city that they have incurred expenses in providing and maintaining infrastructure to those areas that are proposed to be de-annexed. Contrary to, I think, state policy of the legislature, this does not require cities and counties to consider their comprehensive planning. It makes it actually very difficult for a city to engage in meaningful comprehensive planning if there is the potential of property and residents being de-annexed, particularly on a large scale, without the city having an opportunity to be a part of that process. Similarly, it hinders the ability of cities to budget and plan for their financial future, and certainly the stability of the finances for our 537 Georgia cities is something that's quite important to us as a state. Cities would also potentially face higher borrowing costs if it became common practice for large areas to be de-annexed from the city without input from the city or out some consideration of those issues. While there are some attempts in the legislation, and Rushi may speak to this, to address general obligation bonds, there's a lot of other debt obligations that cities take on from time to time, primarily to provide infrastructure. And of course, the state constitution limits what cities' borrowing authority is based on their taxable value that the city can incur. But when cities do incur debt, when they do take out tax anticipation notes, the potential for a large-scale de-annexation would jeopardize the city's ability to repay those obligations, potentially resulting in a default. And we think that's an issue that would affect cities across the state, particularly as bond companies and other financial interests take a look at the stability, the financial stability of the state. Georgia and all of her cities and counties enjoy a very good bond rating because of the stability of the state, and we think that this is something that could cause instability as it relates to tax issues at the state, at the city and county level. So I'm going to ask Rushi if he can to speak to a few specifics, and then he and I'll both be here to answer any questions that you may have.
Thank you, Jim. Good morning or afternoon. I'm not really sure what time it is. Rushi Patel, General Counsel with GMA. And I'm going to apologize in advance because I am going to boil down into a little bit of the language of the legislation. And I think as the author stated and as Jim stated, is a lot of what we are seeing with this legislation is trying to replicate what we see in the annexation side of the law. And I think there is a problem when you try to copy and paste language dealing with one aspect and put it into another aspect. And so we're talking about annexation to de-annexation. As Jim explained, annexation is very different than de-annexation. And unfortunately, when you copy and paste, legal mistakes are made, logistical mistakes are made, and practical mistakes are made. And I'm going to go through some of these right now. So looking at the legislation, I just want to start on the first page. Lines 51 through 56 talk about the city being obligated to de-annex the property unless they can show that there's an issue of health, safety, or welfare of the people in the area proposing to be de-annexed. There's absolutely no consideration for the health, safety, and welfare of the people remaining in the city. That is a challenge because those people still matter. Lines 92 through 95 and 162 through 164 will allow for the creation of unincorporated islands. When you read that language, it seems to prohibit unincorporated islands. However, the current law prohibits unincorporated islands not just within one city, but between cities. And so what this language fails to do is it fails to prohibit unincorporated islands between cities. So, for instance, if you represented Sandy Springs in an area, a neighborhood that bordered Roswell, and was completely surrounded by Sandy Springs or Roswell, chose to de-annex using this process, they would become an unincorporated island. And that is an interesting choice. It also, as Jim mentioned, would create issues with spoke de-annexation because it does not clearly prohibit spoke de-annexation. There's actually language in current code dealing with annexations that prohibits spoke annexation, but that does not exist in this language. Jim did talk about general obligation debt, lines 97 through 99 and 244 through 247. As he mentioned, there are other types of debt and other types of financial obligations that cities can undertake. Revenue bonds. I'm sure many of you have at least watched my Georgia Bulldogs win many games at the Mercedes-Benz Dome. That has been financed by hotel motel taxes partly. Now, if an area leaves and that hotel motel tax revenue is no longer there, that obligation could be in jeopardy. Lines 174 through 189, this is a real big issue in this legislation. 174 through 189 tries to address service delivery issues, but it doesn't understand the service delivery laws in the state of Georgia. And there's been a long-standing precedent from 1976 that states that once a municipality begins providing governmental services it is authorized by law to provide, discontinuance of such services must be justified. So if an area annexes or is part of a city and has provided municipal services and then de-annexes, the city will have to prove that they don't have to keep providing services. So those residents in the now unincorporated area would get city services without paying the price. And that is a real problem. Lines 288 to 290, there are 21 independent municipal school systems in the state. There's not much consideration for how those students would be bounced back and forth. Not consideration for the bond obligations those school districts might have. Those are real challenges. Jumping backwards a little bit, lines 110 to 113 defines municipalities as cities that have 200 or more. This makes sense when you're creating a new city, but we have 50 cities in the state of Georgia that have less than 200 people. So that definition doesn't capture them. Now, I'm not going to complain about that because it means they're not going to have 60%, but this is the thought that was missed. Lines 144 through 146, this language talks about the city bearing the cost of a report and or a list. Now, this is taken directly from the annexation law, but in the annexation law, the city is the one trying to annex property. Here, why is the city bearing the cost of creating the list when they're not the ones that want to get rid of the property? It makes no sense. Let's see. Sorry. Kind of jumping around a little bit. Okay. Let's see. Lines 292 and 303 require the municipality to provide a description of the proposed zoning and land use of the property being de-annexed. Again, this is lifted straight from annexation law. When a city is annexing, of course the city wants to have a standard for what they are proposing the zoning and land use would be. But if the property is being de-annexed, that's no longer going to be in the city. The city has no proposal for what the zoning and land use is going to be when it's no longer in the city. So that needs to be cleaned up. Lines 313 to 325 allows the county to object to a city's denial of a de-annexation, but provides no burden on the county to provide services to the area being de-annexed. There's a whole section of the law called the Service Delivery Strategy Act. The Service Delivery Strategy Act requires cities and counties to review and revise, if necessary, service delivery agreements whenever necessary to change service delivery arrangements. Now, that might sound like that solves that issue, but it only requires a review. It does not require a revision. And a county could very easily say, okay, we're reviewing it, We don't want to revise a service delivery plan here because the city's providing all the services. We don't want to have to. So that is a real challenge. Again, a lot of service delivery issues with this legislation. Lines 326 to 329, cities are able to reject a de-annexation petition if it's detrimental to the health, safety, and welfare of the residents of the property being de-annexed. How is that standard determined? That is going to lead to litigation. That is going to lead to constant fights with this arbitration annexation process that is proposed in this legislation. And then I'm going to get to the arbitration annexation process. It may not be known by the members of this committee, but the annexation arbitration process in current law that the cities and counties go through is actually in current litigation, and it's before the Georgia Supreme Court. The constitutionality of the annexation arbitration process is being debated at the Georgia Supreme Court currently. It may be that by the time, if this were to pass, it may be by the time that it becomes effective, that whole process is void ab initio, that it's no longer any good, because the Supreme Court could have ruled that it's not constitutional. So copying and pasting something that's being debated by the Supreme Court is not a great idea. Lines 463 to 467 literally state that the person applying for a de-annexation, or if the city or the person applying for the de-annexation drops the de-annexation, then the county cannot change the zoning or land use. Well, that doesn't make any sense because the property will still be in the city. The county wouldn't have anything to do with the zoning or land use. These are a number of the issues that we're spotting just looking at the weeds of the language of the legislation. It needs a lot of work if you're going to create another process. We think that the process in the current law makes sense, as Jim described. There are two paths. They can apply to the city. They can apply to the legislature. And speaking of the legislature, I want to give a good example of the problems that this could create. In 2015, a local act went through the General Assembly to de-annex a portion of a city that happened to have the city's water treatment plant. And it led to a lot of litigation between the city and the county that got the de-annexation. And part of that de-annexation led to litigation that talked about the city having to continue to provide services to the area that was de-annexed from the city. These are the challenges that are created. So there are a lot of service delivery challenges, and those really need to be contemplated before this bill moves forward, if it does. Thank you.
Thank you, Mr. Patel. Thank you, Mr. Thornton. We do have some questions, I believe, from the author of the bill, Representative Thomas.
Thank you very much. I appreciate your nice review of my bill. So I'm going to tell you, you've brought up so many different things. I think we're just going to spend some time and go through them one by one. First of all, I want to talk a little bit about loss distributions with regards to reimbursement bonds. You had talked about that. If my understanding is, actually, I'll tell you what, I'm gonna dial it back even further than that. So it sounds to me that the argument that you're making against this is predicated on the fact that there's a concern that there's going to be a mass exodus out of the cities the second that this alternative method is approved. And if that's the case, and if you're predicating everything on that, then doesn't that in and of itself tell me that there's because my issue with this is it's really about property rights, and it's about transparency. It's about the mom and dad who were annexed in. They were at 100% method. They annexed into a city, and they said, "Hey, I don't want to be here. I'm not getting the services that I was promised." That was the whole foundation of the bill. So I guess, like I said, getting back from the beginning, we could start talking about revenue bonds. So you said, well, you're going to lose revenues. Well, if you're providing the services to the hotel and you have the security in the hotel that is doing the things it needs to do, then I don't see any need why they would de-annex. And that's what this is about. This is about, that hotel that isn't getting what it was promised, isn't getting the services it was committed to. Can you talk a little bit about that for me?
Sure.
First?
And I'll, there are 159 counties, 537 cities in the state of Georgia. And I'm sure there are people in every one of those jurisdictions that's unhappy with the level of service that they get from their local government. That's just going to be a fact of life. Now, if you're talking about specifically my example of the hotel motel revenue, it could be that the hotels aren't unhappy with what they're getting, but somebody else in that 60% area is. But that doesn't really matter when it comes to the revenue bond, because that's a financing obligation.
Right.
And so what happens here is if that area de-annexes and something is tied to that hotel motel revenue, and that hotel motel revenue is no longer there, that financing obligation could fail, which could cause financial hardship for the city. So that's the real challenge.
What revenue bonds have been issued on hotels? Like, is that the hotel motel tax?
It's a hotel motel tax.
So are you concerned that all the hotels in your whole city are going to de-annex? Because it just seems like to me, this is only people that are affected on the outer skirts. They literally have to touch the county. So we're not, it seems like to me, maybe we're trying to make a mountain out of a molehill here when it's just a one-off hotel. It's not the whole city de-annexing. It's just
so I'll make 2 points to that. It's not necessarily one property next to a city, and it's not a property that's in the county that has an unincorporated next to it. Because again, the language in this legislation allows for the creation of unincorporated islands. You know, this would allow for, and I hate to bring it up, but it would allow for Buckhead. And
I disagree with you, but that's fine.
Okay. So this would allow for something like that to happen. It would also allow for larger areas to de-annex, not just areas that are the properties that are right next to the city, because of the 60% method.
So one of the things you also mentioned has to do with the concerns about planning. Are you all familiar with growth boundary agreements?
Growth boundary?
Yeah, growth boundary agreements are typically executed between a city and a county. And they just say, these are the boundary that we're going to allow the city to grow into. Are you all familiar with those at all?
Yeah. Yeah, so if I understand, like some cities have and counties have agreements as to what the zoning is going to be in the unincorporated area or whatnot next to the city.
It has to do specifically, well, if you annex into this area, you know, we're going to have some agreements. So it's a mutual agreement that does nothing more than say, hey, you know, we all agree to this. This makes sense. See, because to me, I think one of the things, and I'd like to hear your opinion on it, is do you believe that this legislation actually helps to assist with planning, because it really actually promotes cities and counties entering in these growth boundary agreements, which, by the way, has been done with 2 cities in the county and Cherokee County.
Gentlemen, if I may, I apologize for interrupting. However, we are at a hard stop at 3 o'clock, and we do have one other person asking to speak to the bill, and we've discussing with the chairman next to me here. We've decided this is going to be a hearing only, and we'll encourage the author and GMA representatives to get together offline to discuss these concerns and issues, and maybe we can bring this back up next subcommittee hearing, if that's acceptable.
Thank you, Mr. Chairman.
Thank you. Sorry about that, Representative Thomas. Thank you, sir. And now I would like to ask to come up Representative David Wilkerson.
Thank you, Mr. Chairman, members of the committee. I just wanted to come up to testify in support of the bill. I think both speakers in front kind of highlighted the issue. This has been a tug of war over the last few years between the cities and counties, and we've done a lot of work over the last few years trying to clarify the process when cities are creating annexations. But I think that what the author has done a great job of doing is trying to balance the property rights of homeowners, because right now, a lot of the issues that GMA talked about as far as leaving a city, those same issues exist when you come into a city. So the same service delivery, the same bonds that have been created, and by adding the piece in there that you have to pay for existing bonds takes care of what happens if you create debt and making sure that that debt is not left to those that are left in the city. So this is not about any one particular city. I know in Cobb County we've got our own issues, and I think this would provide an avenue, but I look at this more from a statewide issue, is that there are a lot of homeowners that are just looking for an opportunity to work with their county and cities for what they think is best for them. And by not creating islands, by getting together with your community, by doing that, I think this is definitely a homeowner-friendly bill. And I just want to say I'm in complete support of it, and thank you, committee, for listening to me.
Thank you, Representative. No questions at this point. And right now, I'd like to recognize Representative Thomas just to provide some final comments before we move on to the next bill.
Well, I very much appreciate that. I think there was some, let's just say some things I don't necessarily agree about with the GMA. But one of them, I want to get back to the basics of what this bill is. This bill is about the mom and dad who moved into who was annexed into a city, and they've realized they're not getting the services that they were promised, but they're expected to pay a 20% tax or 30% tax or whatever that may be. That's just an arbitrary number for services that they're not getting. And the only way out is either one, you have to go back to the people that let you in and ask them to let you out, or it's an act of the General Assembly. And I can tell you, as somebody that tried to do a de-annexation, it is extremely difficult to get it through the General Assembly. And on top of that, what this does is it creates an alternative method that of people that are elected, and this was a comment that was made by the GMA. These are people that live in the county and they live in the city. These are elected officials, that the county elected officials that they can go to, they elect to ask for a neutral hearing where they can present their case, and the county can say, you know what, that makes sense. We can support that service, and then be allowed to be let out of the city. That's all this is. It does not stop. They can continue to go through the current process. With one small change, it does say that they need to go to whoever this is. There needs to be a resolution by the county, and that's really I think that's just good practice anyway. If someone's going to de-annex, the county should be okay with that. There's been some feedback with regards to health, safety, and welfare. I felt like that was a really good compromise to the GMA. I didn't have to put it in there. We could have made it at all, but if this does cause problems to the people that live in that area, then there's a problem with that. The sewers or whatever that we build, they're bonded, okay? That bonded indebtedness still has to be paid for. So again, I think this is a really good, solid property rights bill. I think this is a good, solid parity between the annexation and de-annexation process. This is a piece of land. This is a piece of land, and all we're doing is talking about an arbitrary line. That's what it is really the crux. So, again, I'll be more than happy to work on it, and appreciate the hearing today.
Thank you, sir. All right, and next we would ask Representative Daniel to come to the front and present House Bill 409.
Thank you, Mr. Chairman. Thank you, committee members. All right, so I'm looking at LC 472195, just so we're all on the same bill. House Bill 409 will authorize local authorities basically to dispose of real property in the same manner that county governing authorities can currently. This is going to be in addition to the power that local authorities have. So we're not taking power away. It's going to be in addition to what already exists in their local law. The benefit of HB 409 is that those local laws are antiquated and often contain limited tools for sale of property as is. So, I can give you a couple examples if you want them, but overall, we're just looking to make sure that we modernize this in a way that provides some consistency between local authorities and counties. It would allow the authorities to use a more modern, uniform, and publicly transparent method that every county in the state can use. This bill will provide greater uniformity in the law and modernize the powers of local authorities without having to amend each local law individually. Let's see. Another benefit of this is that it should provide more public awareness of the legal process to sell property, because local laws are not as readily available as the Code of Georgia is. And so the idea is that we are providing more transparency for people in terms of how property is sold. And really, it's that simple. So I ask for your favorable consideration and would take any questions if you got them.
Okay, are there any questions on the part of the committee? Seeing none, I don't think we have anyone signed up to speak to the bill. Is there anyone here who would like to speak for about 1 minute to the bill? Seeing none, the chair will entertain a motion. We have a motion to pass? Okay, do we have a second? We have a second. Any discussion on the part of the committee? Seeing none, all in favor say aye. Aye. Any opposed? None opposed, bill passes.
Thank you.
Thank you. It'll be eligible to be called up in full committee now tomorrow, so thank you. With that, we are adjourned. Thank you.
All right, ladies and gentlemen, it is 3 o'clock, and we're going to start, according to Representative Buckner. There is a sign-up sheet on the table for this subcommittee, Resource Management. There will be another sign-up sheet when we get to the next subcommittee meeting, the Environmental Subcommittee. So this is strictly for Resource Management right there. All right, we're gonna start out, and we're gonna start out, and we're gonna ask Representative Williams if he'll say grace for us. Which number are you, Mr. Williams?
I think I had to behave today. I have the Madam Chair Lady sitting by me, so I'll pray for Buddy Deloach, though. Let us pray. Dear Lord, we thank you for this day, and we thank you for all the abundant blessings you give us, and we thank you for natural resources, Father. We ask you to be with us, to lead us, to guide us and direct us, and give us wisdom and help us to make decisions that are pleasing to thee. We pray in Jesus' name. Amen.
Thank you, Mr. Chairman. Okay, ladies and gentlemen, we've got one bill today, HB 436, and this is Chairman John Corbett. And Chairman Corbett, I'm going to turn it over to you. Give us the LC number, and you'll be good to go.
Thank you, Mr. Chairman. LC 510312, House Bill 436. That everybody has. We want the right bill. Okay, Mr. Chairman, members of the committee, what we started looking at the fines and that was levied against mining operations or in the code, and see what if we could update some of them to bring them up to today. And we going through the code, I come across one that's dealing with surface mining that hadn't been updated in quite a while. And so what this is, anyone who willfully misrepresents a fact or matter required by this part of the law and willfully gives false information in an application or report required by this part shall be guilty of a misdemeanor and shall be conviction thereof, shall be fined not less than, the old language was $100 a day and not more than $1,000 a day, minimum of 100, maximum of 1,000. We changed the upper limit to $10,000, and that's all we're doing in this bill is just updating that fine if somebody willfully misrepresents a report or something that's required in law, that they will be fined up to $10,000 a day, and that's at the discretion of the EPD. So pretty simple bill, and that's all we're doing.
All right, Mr. Chairman. Members of the committee, any questions or comments that anyone on the committee would like to make? Okay, we've got Chairman Corbett. Chairman Williams.
I've got a question. Chairman Corbett, could you give us an example of who would be doing type of surface mining in Georgia?
Well, down in my area, there's mining titanium. There's a couple different companies that down there that's doing that, and that'd be considered a type of surface mining.
Okay, thank you. So there are some bad players, and this is going on right now, is what you're telling us.
Well, not they're bad players, but if they are, if somebody does call it, instead of just a little slap on the wrist,
they're really going to be spanked.
This will make it
okay.
Hurt if somebody misrepresents on a report.
Okay, anybody else? Any comment? Mr. Chairman, I think we've got a list of some people that may want to speak to this, and I know we've got a 3:30 subcommittee, so if you don't mind, we'll get this list and see who we have. I will say this, if you've got 2 or 3 companies that are in the mining business, and maybe y'all might be members of the same association, if y'all could kind of have one representative speak for everybody, that'd be great. And not trying to cut anybody off, but we don't want to be repetitious either. So, and we'll speak straight to the source here of the increase from 1,000 to 10,000. All right, good. We just got one on HB 436, and that is Miss Alice Keys. Thank you, Ms. Keys.
Good afternoon, Chairman. Wanted to thank you very much for the opportunity to speak to you today. I want to recognize and thank Representative Corbett for introducing this bill and the other co-sponsors. I am here on behalf of 100 Miles, a coastal advocacy organization based in Brunswick, Georgia. You might have heard from some of my neighbors who are up here for Golden Isles Day. And so it's a real pleasure to be here with you. But the proposed bill, again, we are here to support the proposed bill because it really emphasizes the importance of compliance with the rules and regulations, as well as the permits that are set in place to protect the people and the natural resources of the state of Georgia. I would even go so far as to encourage this committee to consider increasing the amount of proposed fine from $10,000 to something more, just because of, when you think of the fact that a company is spending $300 million to operate a sort of surface mine, $10,000 a day is a drop in the bucket. So I would consider increasing the amount of fine. I also want to recognize and thank the 8 members of this committee that have supported House Bill 71. While House Bill 436 will ensure that current mining operations are in compliance with rules and regulations and that mining is occurring safely, House Bill 71 is all about protecting the safety of communities and natural resources for generations to come. These bills beautifully complement each other, and we are here to support both of them. We hope that this committee will pass HB 436, and that we hope that this committee will also give HB 71 a hearing and a vote as well. Thank you so much for your time.
Thank you, ma'am. Okay, well, we're focusing on 436 is what we're focused on right now, so you got a little free advertisement right there. I'm pretty easy sometimes. The Chairman, have you got something else you want to add?
Just like to add, you know, about making the fines higher. If a air quality or water issue is involved in this, the fines are already substantially higher than this reporting piece in there. Those fines are quite a bit higher if you damage the water or air quality. So,
and that's a discretion of EPD.
That is correct.
Yeah, under Mr. Dunn.
And I would ask for your favorable consideration, and thank you, Mr. Chairman.
Thank you, Mr. Chairman. Okay, appropriate time. Let's make sure you got any other questions or comments from the committee. I'll recognize Chairman Deloach.
Mr. Chairman, I move due pass.
All right, we got a motion and a second. Do I hear any further discussion or comments? All those in favor say aye. All those opposed, same sign. And it's so carried. You're on to the big committee, Mr. Chairman. Thank you very much. Thank you, members, very much, and I'll turn this over to the next committee.
Well, good afternoon. I would like to let everyone know that House Bill 410, we're going to hold that bill if anybody's here for that. We're not going to have a hearing on that today. I think the author has asked to pull that from the agenda today. All right, we got quite a few, all right?
Yeah, you're good.
All right, I think the first bill we have today is House Bill 273. Chairman DeLoach, if you'll come to the podium and explain your bill. And
thank you very much, Mr. Chairman. House Bill 273 is indeed a housekeeping bill. The first change is every year we have to come back, and when we talk about the department's rules and regulations, we have to up the year 1 year to get it current, so we're going from 22 to 23, meaning all those regs in place in 23. That's an annual thing. The other thing we're doing concerns the Sapelo Island Heritage Foundation. Currently, the governor is the chairman of that, and it would seem that he has several other things he has to do from time to time, and really doesn't have an awful lot of time to serve as chairman of that authority. So with his consent, we're changing the chairmanship from the governor to the commissioner. The governor would become the vice chair. We're also changing the appointment process for the residents of Hog Hammock who are on that commission, and we would have the governor appoint 2 of those, whereas the governor appoints 1, and some other way the other resident became a member. And that basically is what the bill does. I would tell you that it's a department bill. They support that, and everybody that's involved supports that. And it is important for us to have more local input into that in that Sapelo Heritage Commission.
all right, does anybody have any questions for the author?
Thank you very much.
Let's see if we got some people signed up to speak on. You can step back and see if anybody signed up to speak to the bill. We do have Mr. Neil Herring, if he will come to the podium.
Thank you, Mr. Chairman. I'm Neil Herring, Georgia Chapter of the Sierra Club. We support this bill. We want to thank Buddy DeLoach for moving this forward. We're particularly glad to see these penalties updated. There was a gap a number of years ago. A fellow had gotten a bunch of flue dust from a steel mill, and he was hauling around pretending it was fertilizer till he killed everything he put it on. And he piled it up in at a schoolyard in Tifton. It was blowing dust across the playground, and the preacher saw it and wanted to know what's that. And turned out to be poisonous flue dust. They brought it back to Atlanta and buried it in Atlanta, which is where you want to put your poison, I think. But when they went to send the man to jail, it turned out that they hadn't updated the rules. What Buddy's doing, they hadn't done it. And they couldn't send him to jail. So he paid a fine, but he didn't do any time. So next time we catch one of those guys, we're going to lock them up, I hope. So thank you, Buddy.
All right, I think that's the only person we had signed up to speak to this bill. What's the pleasure of the committee? That'd be proper time. We have a motion and a second. Any further discussion? Hearing none, all in favor say aye. Aye. All opposed, like sign.
Thank you, Mr. Chairman.
All right, you got your bill. All right, the next bill on the agenda is House Bill 336. Representative Cox, if you'll come to the podium and present your bill.
Thank you, Mr. Chairman.
This is House Bill 336, LC 510306. I'm going to put it simply. Pretty much like sitting in here, it feels like the air conditioning's not working. This is about refrigerant. It's basically changing the code so that new technologies from manufacturers, those new technologies can be accepted in the state of Georgia so that building can continue to happen as the EPA or some other organizations approve new product. At the same time, we're maintaining that the existing systems in our air conditioning in our homes, that mechanical contractors and homeowners can continue to have the same systems that they've had. So it's doing nothing more than opening the door for the manufacturers with new refrigerant so that we get better air conditioning. That's it.
Number 2.
Thank you, Mr. Chairman. So is there a move right now to outlaw or phase out a refrigerant currently used?
So basically, there's what's called HFCs, which are hydrofluorocarbons, and R22 is what we used to use many years ago, and now then R410. So there's the move to slowly fade out some of these refrigerants and new technologies as they come along. In existing homes, you may have 410 or R22. A mechanical contractor may also have that in storage or in stock so they can continue to be used, but there is a phasing out process that's also occurring, yes.
Follow-up question, Mr. Chair?
Yes, I'm sorry, go ahead.
So just to clarify, there is a move to phase out certain refrigerants in use. Does this slow down that process or delay it anyway? It sounds like maybe it does.
No, it does not slow it down. It allows us to be able to build, if we're building a home, that we're not waiting on.
Yeah, I'm not talking about the new ones. I'm talking about the old ones.
Okay, go ahead.
I'm asking you right now, are there standards in place or regulations or whatever that are requiring the phasing out of certain refrigerants? Because I know that the heating and air company that I use has told me that at some point, we're going to have to switch to a different type of refrigerant. So I'm just wondering, does this bill slow down or delay getting rid of the use or stopping the use of certain refrigerants?
It does not.
So it doesn't change the schedule at all?
It doesn't change the schedule.
Okay.
But it allows from a new construction standpoint for the new technologies to be utilized.
Okay, thank you.
Number 15.
Thank you, Mr. Chair. And thank you, Representative Cox, my friend.
Sure.
So I just had a quick question. Is there a significant amount cost related to switching over?
I do not know what the new technologies for manufacturers will be at this point.
Okay. Thank you.
Seeing no further questions, we do have someone signed up to speak to the bill. Mike? No, Rozzy? I think.
Close enough, Rozzy.
Well, tell us who you are and who you're with.
Yes. Good morning, or good afternoon, Chairman Corbett, members of the committee. My name is Mike Nerozzi. I'm the Director of Government Affairs for AHRI, the Air Conditioning, Heating, and Refrigeration Institute. Thank you for allowing me to speak today and convey our strong support for House Bill 336, sponsored by Representative Cox, which will provide the American manufacturers in the heating, ventilation, air conditioning, and refrigeration industry with the certainty needed to comply with forthcoming federal regulations phasing down the use of hydrofluorocarbon refrigerants. AHRI represents more than 330 manufacturers of air conditioning, heating, commercial refrigeration, and water heating equipment. Our member companies produce 90% of the residential and commercial air conditioning, heating, and commercial refrigeration equipment made in North America. In North America, the annual economic activity resulting from the HVAC-R industry is approximately $256 billion. I think I'm losing the mic. In the United States alone, AHRI member companies, along with distributors, contractors, technicians, employ more than 1.3 million people, including more than 23,000 jobs here in Georgia. In December 2020, the American Innovation and Manufacturing Act, or AIM Act, was signed into law by President Trump, which directs the U.S. Environmental Protection Agency to enact rules that will phase down the use of the current HFC-based refrigerants, restricting their use in certain applications such as commercial refrigeration, chillers, and air conditioning. This allows for an orderly transition to the next generation of refrigerants, many of which are made in the United States. However, our manufacturers are facing a pressing challenge. Building codes need to be updated this year to remove regulatory barriers to the use of these new refrigerants. Efforts are underway to do so, both in Georgia and across the country, but the regulatory timelines for these efforts are 2 to 3 years away. This is too late for American manufacturers and for Georgia consumers. House Bill 336 amends the state building code to allow any substitute refrigerant deemed safe under federal standards to be used in Georgia. This will eliminate the mismatch of the building code schedule and allow the use of new refrigerants 1 or 2 years earlier, ensuring that there's no regulatory disruption for consumers by making new products available for sale in Georgia on the same schedule as other states. And I will note that this same legislation has passed in a wide variety of both red and blue states, and Tennessee, Texas, Louisiana, and Missouri are just some of the states that have passed this legislation. In short, House Bill 336 eliminates a critical timing barrier without imposing any new regulatory standards. It simply allows harmonization with the 2024 model building codes, benefiting consumers and businesses that rely on air conditioning and refrigeration equipment. Thank you again for the opportunity to present testimony, and I look forward to continuing to work with the Georgia General Assembly to achieve the economic and environmental benefits of the phase down of HFCs. Thank you.
Cost-wise, the new refrigerant as compared to the R22, I know you can't get R11 and R12 anymore, but you can still get R22.
With the new refrigerants, there won't be any noticeable increase in price to the consumer. In fact, most consumers aren't even going to realize that they're using the new type of refrigerant. It's simply just going to be manufactured into the new equipment as it comes onto the market. The old refrigerants, actually, this EPA phase down leaves about a 15% reserve of the current HFC-based refrigerants specifically to service older equipment, so folks can still service their older equipment. So yeah, the cost of the refrigerant in HVAC systems is typically about 1% of the total cost. So there won't be any, shouldn't be any noticeable difference in the cost of the equipment.
Okay, we have a question, Representative Campbell.
The new refrigerants are some already up and ready, running, or still out in front of you to build?
Yeah, actually, 80% of automobiles that are manufactured that are sold here in the United States have these new refrigerants in them in their air conditioning systems. So this would just move to residential and commercial.
Okay, thank you.
I don't see any more questions. What's the pleasure of the committee? We have a motion, and we have a second. Any further discussion? Hearing none, all in favor say aye. Aye. All opposed, like sign. Thank you. All right, we have one other measure on for today, and that's House Bill 396, Representative Vance. We started this morning together, and we're going to end this afternoon together, looks like.
I hope this one goes better than the one this morning.
Me too.
Thank you, Mr. Chairman. This really is, it's LC, LC 460551. It's, you know, it's House Bill 396. This really should be a local bill, but since there was an authority created under statute in 2006, the board, the current board as it's made now, has asked that we add the president of Georgia College and State University to the Greenway Authority. And that's it.
Is this your first bill?
It is this afternoon. My first one was this morning. Didn't do too well. Y'all help me out here.
You was pinch hitting. You was pinch hitting for somebody this
Yes,
morning.
sir.
I think you.
Yes, sir. So this is my first bill. Yes, sir.
We do have a question. Number 7.
To my good friend from Milledgeville, you're a great improvement over your predecessor. But I do want to ask you because I want to clarify the Oconee River Greenway Authority. Is that like an economic development authority for bonding? What exactly does that authority do?
No, sir. The Oconee Greenway Authority represents the Oconee Greenway. It's a recreational area that was established by me when I was a city councilman in Milledgeville, Georgia. We bought up land along the river, improved it, made bike paths and walking paths out of it. Also, the Georgia Military College Rangers use it as a training ground for some of their activities, and that's what it's there for.
Okay, thank you.
Thank you.
All right. Now, I think first time you and I met, you said you was the quarterback for Tift High School
Many years ago.
Many years ago, and you reminded me of when you used to play in Valdosta. You a very memorable.
His
event.
name was Mike Everson. He was number 67, and he knocked me out. No.
So I mean, how many years ago was that?
That was 1970.
So 52 years. That was a memorable hit. But anyway,
you would have too.
But anyway, I don't see any other questions. What's the pleasure of the committee? We got a motion to pass. Do we have a second? Any further discussion? Not hearing any. All in favor say aye. All opposed, like sign. You have your bill. I like those.
Thank you, sir.
Thank you. And the meeting is adjourned.